the rule of law in this country and the concept of equality before the law is rapidly going away. And it was here in San Bernardino County under the incumbent DA. Let's try that. So we were pleased to support Jason Anderson in his successful campaign to replace the current incumbent DA, and at least in this maybe this little corner of California, restore the rule of law and equality before the law. You've asked Jason to come and address two things tonight. One is something that hasn't gotten much attention, AB 1810 that passed last June, that lets any criminal, any charge, as I understand it, is potentially this applies to. If they claim there was a mental disorder that contributed to it, then they can get psychological counseling instead of going to jail or being convicted. And it's just incredible that the Democrats would pass such a thing. Then they just abolished bail, so this began releasing even more criminals with no incentive to show up for their court date, and no bail hunters to go out, bounty hunters to go out and find them if they don't show up for their court date. So yet more criminals back out on the street, and it's unfortunate news. We've asked Jason to come in and explain what's going on with those two things and what we might be able to do about it. Jason. I would just add that Jason is probably not how Jason usually goes to court. But to be more frugal, and given the high gas taxes in California, he rode his motorcycle over here today. So, Jason.
Greg, thank you very much. I appreciate that. I did text Greg. Please apologize. How's that? Better? Thank you very much, Greg. Marilyn, it's a pleasure to be back. I really appreciate your guys' support on the campaign trail. It meant the world to me. You guys were the first to come out and get behind me and support me. I appreciate that. As Greg said, I apologize for my casual appearance. Actually, I rode my motorcycle because of Jerry Brown's freeways and exorbitant gas prices. I thought I would save time and money. But that's kind of an anathema to state government, so I figured that was my way to protest. And it's a lot more fun, honestly. So, Greg, I appreciate the opportunity to come out. Two things that have gone on. AB 1810, I'll talk about that first, as Greg refers to it, is the mental health, mental disorder bill. A couple issues with it. I'll give you locally what's going on in terms of its application and how it's trying to be applied in San Bernardino County. The first big problem with it is that there's no legislative history. It was a rider bill. There's just simply no legislative history behind it. And the reason that's a problem is that the mental disorder is not necessarily a problem in terms of the definition. What the difficulty is the person who gets to determine if it is a mental disorder. It's not defined in the statute. There's no legislative history to say who does it. We don't know yet if it's going to be a social worker. We don't know if it's a psychiatrist. We don't know if it's a psychologist. None of those things have been determined, and so obviously you know there's going to be a certain push on one end of the spectrum to make it someone who does social work, which is fine. I'm not critical of social workers. I work near and dear to a lot of social workers, but when you're talking about defining a mental disorder as it relates to crime of violence, you can see the difficulty that may be in terms of what is the standard going to be. There's not even an indication that's going to come off of the DSM in terms of any psychiatry or any other mental health definition. So it's very nebulous, and there's no legislative history to it. Locally, what's happening is, in terms of the application, I've been present at some of these meetings, is that the judges, along with the public defender, the district attorney's office, the Department of Mental Health, probation, have all gotten together to try to figure out, because it is a diversion program, where is each discipline going to fall in terms of who gets recommended to the program. And so, as you can imagine, on the one side of the spectrum, the public defender's office is going to want a much wider breadth there in terms of who gets appointed into the diversion court for mental health, whereas the district attorney's office is going to be worried about any crime of violence, whether it's a misdemeanor or a felony, obviously prior record and things like that. So we're discussing it. It's not online yet in terms of people getting referred to the diversion program. And I want to make sure that you know what is meant by a diversion program. And Greg is accurate when he says that. Is that a diversion program says that there will be no criminal conviction depending on the treatment that is sought by the offender. Currently, there are diversion programs that you may be aware of, like PC 1000, RISE, for low-level drug offenses, first-time theft cases. If someone goes in and steals $50 or $100 of items from a store and they have no prior record, they may get diverted to where they walk out after doing a program and have no conviction. So when you're talking about AB 1810, it's the same kind of diversion program. There is no cap on the type of crime that can go in there. So it is going to cause some problems. There are going to be rigorous debates in terms of what cases the DA's office is even going to allow to go in there. Ultimately, right now, in terms of the bill itself, in terms of the ultimate determination is the judge. The judge gets to determine that person, he or she is the gatekeeper. So it's very important that we understand in the county which of the judges will be in charge of each of the districts. So there'll be a West End in the Rancho Courthouse, there'll be a Central in terms of San Bernardino Justice Center, and then there'll be Victorville. So there'll be judges in each one of those courthouses, so it'll be important for us to make sure that we have sensible judges that understand the impact of a program like this in terms of what it could mean for the residents of San Bernardino County when it comes to crimes of violence and for what I would refer to as your broken window types of crimes, a lot of which are covered by Prop 47 that turn things into misdemeanors. Getting your car broken into, getting your car stolen, all that kind of stuff. So it's in the works. It's not online yet, but it's in the works. But the problem is that the person who's defining whether a mental disorder exists, that's the area where it's not very well defined, and that's what we need to work on in terms of who's going to be the person that's making that call. In terms of the SB 10, so we've abolished cash bail in California. A couple different problems with that. Number one, the California Constitution calls for bail for people, and so what's happened is you now have another piece of legislation that has overridden a provision in the Constitution. So there may be some issues in regards to the legality of that. I know that there's an attempt to put a proposition on the ballot, particularly by the bail bonds lobby, to try to overturn it. Procedurally, there is talk that if that qualifies, then the application of SB 10, which is to take place in next October, so October 2019, that will be on hold. So procedurally, there may be a delay in the application of SB 10. Let's assume that it goes into place. What does that mean? In fact, I was at a meeting today at the courthouse with the presiding judge there and other attorneys in the discipline. So here's what it is. It's no more cash bail means there's going to be a pre-trial detention review of every case. So if bail's not set, there's got to be some way in which there's a determination of who's going to get released. Probation will be the main discipline that does the pretrial detention. Again, the judges will make a determination based on a pretrial detention review as to who gets released and who doesn't get released. Remember, there's not going to be any money involved. It's going to simply be a decision by a judge based upon risk factors that probation is going to indicate. Here's the problem, a couple problems with that. Number one, San Bernardino County probation doesn't have the resource to take away from people they're already supervising that are on felony probation to come in and have a separate pre-filing detention court where there's going to have to be hearings. And you can imagine that in terms of if probation, based upon someone's failures to appear, their prior record, recommends that someone should not be freed pending their trial, then defense attorneys are going to want to have a hearing. Mainly public defenders are going to want to have a hearing. So then it's going to require another resource of a judge to determine that hearing. Again, none of these resources have been thought about in SB 10 in terms of what it's going to have on the local level in terms of that. Now, so ultimately, it's kind of like AB 1810. The judge will be the final arbiter of who gets released on detention. So right now, we don't know what the impact is going to be. Clearly, there are going to be more people at the mid to lower levels that are committing crimes that are going to be released and that are never going to show back up to court. The question that no one can answer now is that how do you get those folks back into custody when they fail to show up time and time again? Because currently, bail is set, they can't make that bail number, they stay in custody, makes everybody safer, and it makes it easier to resolve a case. There is no answer to that in terms of what will happen. One solution that we've offered is that once somebody hits that period where they've been released pre-trial detention and they don't show up, that then the judge clearly can order that that person no longer be released prior to trial. So maybe they'll only have one failure to appear, that remains to be seen in terms of that. So that's what's going on with that. I'll be honest with you, from a practical standpoint of practicing law for over 20 years, what bothers me the most of these two is the AB 1810. The abolishing cash bail, to some degree, may actually at some point actually keep more people in custody pre-trial before a trial than cash bail will. Oftentimes the way cash bail works now is that the level is very low. Sometimes the amount is negotiated between what they owe to the bail bonds and what collateral is, so it makes it easier for someone to get out. So if you have a bail of $50,000, on paper you have to post $5,000 cash. That's not necessarily the case. Under SB 10, there is no money. And so the judge, in their discretion, could just decide, we're not going to allow you to be out. So it may be that it actually has a better impact in terms of keeping people into custody. Again, it's going to come down to the judges. I can tell you from experience that generally in San Bernardino County, we have some pretty conservative rule of law judges that realize the impact of what they're doing if they're thinking about releasing somebody on a crime of violence into the community, or someone who has a track record of not showing up to court. But it's AB 1810 that is the real concern, because this is a major overhaul of a diversion court that includes all crimes with no legislative history, and it's left again to the local level to try to figure it out. I can say that I'm thankful to be in the position to be coming into the office to try to deal with this, because I know often what times diversion programs become is a get-out-of-jail-free card. Every time there's been a diversion program in California, it always has the highest expectation if it's only going to be this small amount, and then it quickly turns into the rule rather than the exception, and that's going to be really concerning with 1810, because what Greg said, there is no limit, or there is no characterization of the crime that it covers, and that's going to be concerning to us when you're talking about crimes of violence, whether they're misdemeanors or felonies. So I hope as we retune this, perhaps I can come back as we get a little bit more structure from all of the disciplines in the county, Department of Behavioral Health, probation, the bench, the DA's office, the private bar. I can come back and give you an update by the end of the year, once it goes online, to give you a real application of what's happening. I'm sorry I don't have more details, but it is that new, and if we had some legislative history and somebody actually did their job and thought through the law before they imposed it on it, I might have more to talk about. You guys would probably know more about it anyway. You wouldn't need me to talk about it. But I'm happy to come back and do it when I have the opportunity. So, Greg, I hope I didn't go too long, but these are big, big issues right now. So, Carolyn, thank you very much. I appreciate the opportunity.
Before you run off, mental disorder is much broader than the traditional insanity, isn't it? Mental disorder is much broader than in traditional insanity defense.
Oh, absolutely, no question about it, because again, the question was in terms of mental disorder. That has nothing to do with whether you're determined competent to stand trial, or whether you would be a judge to have been insane when you committed offense. You didn't know the difference between right and wrong. You did the act, but you didn't know the difference between right and wrong. Those are set standards. Those standards have been litigated for 50 years in this country. Mental disorder is in parentheses, and there is no definition of what that mental disorder is. And again, the problem goes back is to who's going to be the person who's defining that the offender suffer from a mental disorder. I'm not here to say that there aren't certain crimes that are committed because people have mental health issues. No one's denying that. But when you're talking about crimes of violence and you don't have definitions here, and you don't really know who the person who's going to be the gatekeeper in terms of defining a mental disorder, that's the struggle we have on the local level. That's the difficulty. But yeah, you're right, Greg. It's much broader than any concept or definition of not guilty by reason of insanity or not even being competent to stand trial. So
I read an article by the head of the Los Angeles County DA's Association, I forget her name, that said that only the defense can put in psychiatric evidence under AB 1810. Is that correct?
They would have the burden in terms of putting it in, but it can be refuted in terms of experts that the prosecution may call, or cross-examination of the defense expert. So in that regard, it works a little bit like the defense of insanity. If you plead insanity, then the burden's on the defense to show that you're actually insane, because the law presumes that you're competent. So it's sort of that same standard. So,
I have a question.
yes.
I'm a Virginia County doctor, and so if we were to assume original people have mental disorders,
The applause drowned out the last part there.
What's the treatment for that?
Well, some things are incurable, I think. We just have to raise our hands and go, that's the way it's going to go. So it's really going to be, here's the real rub, and everybody knows it. The real rub is it's a continued push on the resources on our system at a local level, right? Even if you get it right, let's assume in utopia, San Bernardino County can actually work out AB 1810. It's the resources that we don't have, and there's no monies as a result of this bill to come down and filter down at the local level. And so again, what you're doing is you're pressing probation, you're pressing the Department of Mental Health with resources that otherwise would be used in positive ways to now react to something like this and take away all that manpower, those man and women hours to worry about what this is going on. And it really is a draw of the resources. So that's the real downside. To say nothing of public safety. Yes.
Well, people who unfortunately get arrested for family violence or domestic violence be able to spend enough time in jail before they're let go to sober up and calm down, maybe a couple of days, 2 days?
Yeah. In fact, I've talked about this with some of my colleagues. One of the reverses that we likely will see through SB 10 in terms of pretrial detention is the situations that involve domestic situation where if they're not held, they go back into that environment that's going to be toxic and oftentimes leads. I don't think you'll see any judge in this. Most of the judges that I practice in front of, those offenders will not be released, right? At least not until there's an opportunity to get the CR 160, which is a restraining order that goes into the California law enforcement system that can be pulled up. But I just don't see from my experience, again, you got to remember, from a practical standpoint, the judges got to be thinking in their mind, do I want this to come back on me if I release somebody in a domestic violence situation and it goes even worse? I just don't think you're going to see that kind. So in some ways, those are the areas where I actually think you'll see more people incarcerated pre-trial than you normally would. So that is good.
Thank you, Jason.
Thank you, Jason, for coming this evening. Let's give him another big hand. A big thank you.